This courtroom hearing is about far more than one bad decision. It's about credibility, accountability, and how quickly second chances disappear when patterns repeat. Audrey Bash stands before the court already on felony probation, now asking for yet another opportunity after picking up a new offense. The judge isn't just listening to words, she's watching body language, comparing statements to records, and weighing whether rehabilitation is truly possible outside of custody. As this hearing unfolds, we'll see promises collide with paperwork, explanations fall apart under questioning, and a moment where hesitation speaks louder than any argument. Stay tuned, because the decision that comes at the end will change everything.
And see, this tells me right now, she really doesn't want the help that she's trying to figure out back. 8991, State versus Audrey Bash. Can I have parties announced for the record?
Joseph Stateson for defense.
And are you Miss Bash?
I am.
All right, you entered into a plea bargain agreement with the state. You applied for deferred adjudication.
Right here, the court
and
lays out the
also
legal
for
framework of
communities.
this entire case. Audrey has entered a plea bargain requesting deferred adjudication and community supervision with a punishment cap of 6 years and a $2,000 fine. Deferred adjudication is critical. It means no final felony conviction yet, but only if probation is successfully completed. The concurrent nature of the cases helps limit exposure, but it doesn't erase responsibility. This is the fork in the road moment. Comply fully and stay free, or violate conditions and face the full weight of the prison system. Everything that follows will determine which path she ends up on.
Supervision. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. This is the run concurrent with 2024 CR 2272. State will take in consideration 2025 CR 008992. Have both parties had a chance to review the TAP evaluation and PSI?
Yes, sir.
Yes, Your Honor.
Any objections from either party?
No, stay here.
Just a few corrections, Your Honor. I reviewed it with my clients, and you have a copy of it.
Yes.
On page 1.
This section may sound technical, but it's one of the most important parts of the hearing. The defense is correcting the pre-sentence investigation report, the PSI, which judges rely on heavily when determining punishment. Every detail matters here: prior prison trips, employment status, education history, and substance abuse background. These corrections aren't just clerical, they're about credibility. When a PSI contains errors or inconsistencies, the court has to decide whether they're honest mistakes or attempts to minimize responsibility. Judges hear promises every day. What they trust are accurate records. This moment sets the tone for how much confidence the court will place in Audrey's version of events.
Although this goes more towards argument, guilt minimalized, on the PSI specifically is for the firearm. I believe what they're referring to is for the case that's being TIC'd, but she admitted there was a firearm. And for argument, I will explain further for that, but she didn't minimalize the handgun. She acknowledged there was a handgun. On page 2, everything's correct on page 2, but on page 3, under other cases outside Bexar County, Kendall County, Texas, she said that there was no state jail prison trip on Kendall County.
Okay.
It was only one state jail trip on page 2, one TDC trip on page 2, and she didn't have a third trip to prison. Same page 3, Tarrant County, just so the court's aware, April 9, 2025, under Tarrant County, Texas. She was in custody here. The typo, it should have been 2015. If you look at the convicted 180-day jail, 11/23/2015. I just don't want the court to be thinking that she had a out-of-county case April of this year when she didn't.
Okay.
Also, page 5, where it says unemployed, she did report that she's self-employed. She has her own landscaping company. She's able to provide for herself if she was to be granted probation. On page 6, it says that she Although to the left it says none for DWI education, to the right it says yes, which could be for AANA. She has done AA. She just wants the court to be aware that she's never had a DWI. She's never had to take DWI education class. And page 9, although this is not really a correction, it's just so I can point out, they wanted proof of full-time employment under other within 30 days and provide proof of education within 30 days. She's saying that she received 2 GEDs, one in Arizona, one in Texas. In 2001 and 2017, she did have a GED. The 2017 was in Bexar County Jail. Aside from that, there's no other corrections, Your Honor.
All right. State, you're opposed to the application?
Yes, Judge. Yeah, again, I don't have any evidence.
Okay. All right. Anything your client wishes to say?
Yes, Your Honor. I would like to call her, but if I can do some argument first. We were here previously.
Well,
Okay.
I think it's best that I take testimony and then I'll allow both parties to do argument.
Can I call Audrey Bash?
Yes. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand.
Ms. Bass, you're currently on probation supervised from this court. Yes?
Yes.
All right. You need to speak up so the court reporter can.
As Audrey takes the stand, the judge immediately asserts control of the courtroom. The insistence that she speak clearly isn't about impatience, it's about the record. Every word matters, especially when someone is asking for leniency. When the judge asks whether Audrey is willing to do anything required on probation, the answer comes quickly. But the follow-up question is devastating. If you're willing now, why weren't you before? This moment exposes the core contradiction in probation cases, motivation that only appears once jail time becomes real.
Here.
And you're asking this judge to grant you reinstatement and probation on this new offense?
Absolutely. Yes. Yes. Yes.
You're willing
Okay,
to
so here's the thing. I can barely hear you. You're a distance away from the court reporter. I know the court reporter is struggling. You need to speak up.
Yes, ma'am.
Yes.
you're willing to do anything this judge imposes of you for probation?
Absolutely.
And
Then, I'm sorry. Then why haven't you been doing it? Like people always say, I'll do whatever you want me to do on probation. You're already on probation. In your statement on page 7,
This is where the judge's frustration becomes clear. She isn't reacting emotionally. She's reacting logically. The court points out a pattern seen over and over again. Defendants suddenly become compliant after they're arrested. Classes get taken, goals get announced, promises get made. But probation happens in the free world, not behind bars. The judge's question cuts deep. Why should this time be any different? From a legal perspective, probation is about self-discipline. If accountability only exists in custody, supervision outside of jail simply doesn't work.
states, when asked why she felt she should be granted probation, the defendant stated, "It's hard to be in jail. I don't want to be here or in prison." If you don't want to be in jail and if you don't want to be in prison, then why do you keep doing this?
I was doing my classes. I was told to do the IOP classes here. I did 18 out of the 20. The day I came to jail would have been my 19th.
But we're here for a new case. That means that you picked up a new offense.
Yes, ma'am.
So why? Why do you keep doing this? It seems like you want to go to prison.
I do not, ma'am.
Then
I know to be better, I have to do better. And since I've been in here, I've done every class that they could give me. I'm trying to do better. I
here's
do
the thing,
understand
people
that.
always do better when they're in jail. Normally, I will have people, they come before me, and when they're in the free world, they don't do what needs to be done. When they're in the jail, it finally hits me. Oh, I'm in.
Here, the judge explains a hard truth about the justice system. Jail creates structure. Probation requires initiative. Many people thrive temporarily when rules are forced on them, but struggle when responsibility becomes optional. The court highlights something telling. Audrey has completed her GED twice. While that may sound impressive, the judge sees it as evidence of misplaced focus, doing what's available in jail rather than what's required on probation. This isn't mockery, it's analysis. The judge is explaining why jail success doesn't automatically translate to probation success.
In jail. And then they start taking every class they have at the jail, as evidenced by the fact that your counselor is saying, I've done my GED twice, when you only need to do it once. But people always become focused when they're in jail because they don't want to go to prison or they don't want to be in jail. So my question for you, why would this be any different than before?
Your Honor, I'm old, and I know that I just don't want to do this anymore. What happened was I let fear control me and make a bad decision, and that was wrong. I was being threatened.
So how old are you?
42.
So you've had this MTR since last year.
No, ma'am.
Well, you were
When Audrey cites age and fear as explanations, the judge doesn't dismiss them, but she contextualizes them. At 42 years old, this isn't a youthful mistake or a first encounter with the justice system. The court carefully walks through timelines, pointing out that probation was imposed recently, not decades ago. This moment underscores a key principle in sentencing. Maturity increases responsibility. The judge isn't questioning whether Audrey feels regret. She's questioning whether regret has translated into consistent, lawful behavior.
placed on probation on 2024.
September. And
So, I mean, you were maybe a year younger than you are today.
and I was really trying to do everything that I could, and I do believe that I can do better. I if given the chance, I know that I can do better. I can be better. I can do better. I do
Your Honor,
believe that.
the threatening that she had, she is a victim of robbery. I tried to find it. I went back in time on YouTube to try to find it. There's a case here, family violence. Rick is familiar with. I've asked Rick to pull up the case information. He couldn't find it. I was in court here, and there was a Spanish sentencing, and there was a person who was very loud, talking in Spanish. I don't speak Spanish, but when the state had said that there's multiple victims, that lady was sentenced to prison. They said that the restitution was owed to Audrey Bash, but they didn't know her location at the time. I've asked them to try to find that. I couldn't find that case. I don't have a way to search that. But she understands that a gun is not supposed to have a gun on felon's probation. If she were to have a gun after the 5-year period elapsed after he was discharged, and cases ended at her house for protection. But she had some bad relationships. She had struggled. She had a relapse. She wants to be a licensed clinician, dependent counseling to help other addicts recover. She believes she can stay sober. She won't be around firearms. I've never had somebody take upwards of 20 classes at the jail. People usually take 2 to 3. And she not only took, I think it was 19 classes, but the AA meetings and 10A meetings she's done, it's multiple. It's not just 1 or 2. She's actually participating. She's not crossing her arms, defiant. She's willing to do probation. It's her first MTR. I know that there's 2 new offenses, helping that you would give her a chance.
All right, state.
I guess I did have some questions for the defendant.
Oh, you may proceed.
Ms. Bash, so you were placed on felony probation in September of 2024, correct?
Yeah.
Okay. And your
Now the
analysis, is
tone
that correct?
shifts.
And
The
that was
state begins
positive for
methodically
amphetamines and
dismantling
marijuana,
Audrey's
correct?
narrative,
Okay.
using
Okay,
dates,
and then
addresses,
in
and probation
February of
conditions.
2025,
This
you
isn't
did not
aggressive,
appear to
it's
provide
precise.
a urinalysis, correct?
Misreporting dates,
I don't
failure to
remember.
update an
I don't
address,
remember
and confusion
told
over
to do it
basic
that day.
probation
You
requirements
don't remember
raise
being
serious red
informed of that,
flags.
do you?
When someone's
Well,
on
I guess
felony
it's fair to say the
probation,
last time that you did
communication
it
with their
was in
probation
January
officer
2025,
isn't
right?
optional. It's the foundation
Okay.
of supervision. Each unanswered question here chips away at the argument that Audrey was genuinely trying to comply.
So as part of your conditions of probation, you were supposed to report to your probation officer. Do you recall that?
Yes.
Okay. And so it would appear that the last time that you reported to your probation officer was in February of 2025. Is that correct?
No, I didn't. March also, I was in my class and my teacher, we reported by phone.
I'm talking about going to the probation officer and meeting with your assigned person at the field office. Okay, so the last time you did that was in February 2025, correct?
Yes, ma'am.
Okay. And the address that you provided to probation at the time that you were placed on there was 1126 King Avenue, apartment 6. Were you living at that address up until your arrest?
No, yes, no, ma'am, I had moved, but I told them on my mother.
Okay, and what was you told them your new address?
Yes,
Okay. Now, as part of, because you are on felony probation for drug possession, you acknowledge that, right?
Yes.
Okay, and so part of the conditions that the court placed on you to help address this issue is for you to go to partake in urinalysis. You recall that, right? Okay, and so you had been ordered many times. So starting in January 2025, you did report to provide a urinalysis. Is that correct?
yes,
And that was positive for amphetamines and marijuana, correct?
I believe so.
Okay, and then in February of 2025, you did not appear to provide a urinalysis, correct?
I don't remember. I don't remember being told to do it that day.
You don't remember being told to do
No.
it that day? Well, I guess it's fair to say the last time that you did it was in January of 2025, right?
Okay.
So the last time that you provided urinalysis was in January of 2025?
Yes, ma'am.
Okay. And so then in your PSI, you deny that you were under the influence of any alcohol or.
This is one of the most damaging moments of the hearing. The court confronts inconsistencies between Audrey's statements and the evidence, positive drug tests, denial of recent use, and conflicting timelines. When the judge walks her through the math and exposes the contradiction, there's no room left to maneuver. Honesty is the currency of probation. Once the court concludes that a defendant hasn't been truthful with the PSI officer or the judge, trust collapses. And without trust, probation becomes impossible to justify.
Drugs at the time of your new arrest. Do you recall that?
Yes, ma'am.
But when we look at the stipulated evidence, the officer states that when he approached you, you appeared to be sleeping in your vehicle. Do you acknowledge that?
Yes, ma'am.
Okay.
It was raining and the roads were wet and I pulled over rather than getting in an accident, I fell asleep driving one time before and I killed myself. And I would rather not do that again. I wasn't on drugs because if I had been, I would have been awake.
Okay. And so
I
what
didn't
is
know
this
they
that the
were-
officer is saying that he could smell marijuana in your motor vehicle?
I was asleep. I wasn't smoking, I was asleep.
So when was the last time that you smoked marijuana in that vehicle?
I don't remember.
You don't remember?
No.
Okay.
And I don't think it was me. I think it was the person that I let my car to. Earlier that day.
Okay. So then further in your PSI, you state that the last time that you had used methamphetamines was 10 months prior to your arrest. Is that what you said?
I believe so.
Okay. But
I
you were found in possession of methamphetamine on the
did,
date
yeah.
of the offense, correct?
I did not know that it was there. If it had been mine, it would have been on my person. I would have known that. I didn't know that it was in the floorboard of my car because I gave somebody a ride to work. It would have been, in my possession. I really did not do that.
Okay. Well, notwithstanding you disputing those facts, okay, you were arrested in May of 2025 and had a positive UA while on felony probation for methamphetamines in January 2025. So please tell me how many months that is. It's 5, right? Not 10. So you're not being truthful to your PSI officer or this court about what you're doing on felony probation, correct?
Yes, ma'am.
Okay. And then further in your PSI, you're stating that you should be granted probation because
This exchange strikes at
you
the
should
heart
be
of the
granted
case.
probation
The
because
judge
you
points
don't
out that
want to go
Audrey's
to
stated
jail.
reason for
Not
wanting
because you want to
probation isn't
change or not because you
It's
want help,
avoiding
correct?
jail. That
I
distinction
want help,
matters.
ma'am. I want,
Courts are
I
designed to
would like
offer
help. I'm trying to
rehabilitation,
be a better
not
person. I'm
convenience.
doing everything that I
When
can to
someone
be
wants
a better
probation
person.
only
Okay.
because
So
incarceration
if
is
you
difficult,
wanted help,
it
why
suggests
did you not
motivation
reach
rooted
out
in
to your
comfort
probation
rather than
officer? Or
commitment.
why did you not show up
The
to your
judge isn't being
UAs?
harsh here.
Or why did you
She's
not
being
show up here to
honest.
the court to ask
True
for that?
I was
rehabilitation
doing the
requires
classes and
proactive
I
effort,
was
not
doing the classes
reactive
that they
fear.
gave me.
You don't want to go to jail, not because you want to change or not because you want help, correct?
I want help, ma'am. I would like help. I'm trying to be a better person. I'm doing everything that I can to be a better person.
Okay. So if you wanted help, why did you not reach out to your probation officer? Or why did you not show up to your UAs? Or why did you not show up here to the court to ask for that?
I was doing the classes and I was doing the classes that they gave me, the IOP classes here at the probation office. I had reached out to my teacher and told her that I was having a hard time. But I was doing that. I mean, I thought that there would be a record of that.
Did you notify anybody that you were actively engaging and using controlled substances besides your IOP teacher?
No, ma'am.
Okay, because you understand that the IOP teacher is not the correct person to report that to. It's your probation officer, right?
Okay.
You understand that?
I'm doing that. Yes, ma'am.
And so I guess ultimately what you're telling this court is that you just don't want to go to jail or prison because it's hard, right?
No, ma'am.
That's what you
That-
stated in your PSI, right?
and it's not that that's not it at all. I would really like to be given a shot to be a better person, to do better, to prove to myself and the court that I can do better. Prison is easy. I mean, you do what they tell you to do and that's it. But when I've done probation, I've free and cleared probation with no violations. I've free and cleared parole with no violations. I believe that I can do better. I truly do. I want to be better. I know to be better, I have to do better. And I'm prepared to do that. I know that probation is very rigorous and I'm prepared for those things. Anything that you give me, and I'll be happy to do. I want to be better and do better and help others be better and do better.
Okay.
I believe that.
Well, would you agree with me that given your history, the state and this court has already given you a chance by placing you on felony probation? And here we are because you cannot violate or you cannot abide by the terms of felony probation. You'd agree with me, right?
I believe that I made a mistake once and I would really just beg mercy to please get a second chance.
When you say that you've made a mistake once, I mean, this is not the first time that you've been charged with a criminal offense, correct?
Mm.
So that's more than once, right?
I'm asking for a shot, a second shot for this, but I don't know what to say there to her anywhere she's.
May I briefly
Pass the
respond?
witness.
All right, so I'm going to give you a choice today. These are your choices.
This
There are
case
no other
ends with a
choices.
5-year prison
One.
sentence, concurrent on multiple cases, credit for time served, and a felony conviction that permanently alters Audrey's future, including the loss of firearm rights and limited avenues for appeal. The judge followed the plea agreement precisely and reinforced a core message of the justice system. Probation is a privilege, not a safety net. Courts will offer structure and help, but they will not chase compliance.
I can place, you say you want the help, I'll give you deferred adjudication. The state is offering you a cap of 6. If I give you deferred adjudication, the full range of punishment is open to the court, which means up to 10 years in the prison. You are not going to ISF. I don't think ISF is appropriate. You'll be at the jail waiting transfer to SafeP. And the SafeP program is a 9-month program. And then you have aftercare for 3 months. Or if you would like, I'll sentence you to prison. I'll sentence you to prison for 5 years. Those are your only 2 choices. Which do you choose? And see, this tells me right now, she really doesn't want the help, that she's trying to figure out back time. But you can discuss it with her. No, those are my only 2 those are your only 2 choices. There are no other choices. You can either do 5 years in the prison, or either you are going to do 10 years deferred adjudication. Those are your 2 choices. No other choices for you. So which do you prefer?
I'm sorry.
One moment.
All right.
Oh.
And if she chooses prison, it doesn't hurt my feelings.
Your Honor,
Yes.
we're ready to proceed forward. She has her answer.
Right. So which does she prefer?
5 years TDC, and we would ask that would run concurrent with her MTR. We would ask if you would reform the judgment of the 10-5.
Oh, just 1 second. We haven't done that case yet. All right. So in cause number 2025 CR 008991, the court will sentence you to 5 years in the prison. I'm sorry, the court is going to find you guilty, sentence you to 5 years in the prison. Give you credit for any time served. This will run concurrent with 2024 CR 227. I'm sorry, is this 2272 or what? 2272. Take in consideration 2025 CR 008992. And I'll request the therapeutic community. Is there anything else in that case with regards to sentencing?
Yes.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand?
I do.
All right, we're going to proceed in 2024 CR 2272, and that cause number you previously pled true to violation of condition number 1. The court found violation of condition number 1 true. And your range of punishment on that case, the court could sentence you anywhere up to 10 years in the prison. And state, what are you requesting?
Judge, we are asking for revocation and 5 years to run concurrent with the prior cause.
That's our recommendation. We ask that you follow it. I've previously conferred with Megan. If there was revocation, we would ask you to reform the judgment to match the sentence.
All right. Are you waiving your right to appeal?
I am.
Okay.
Thank you, Judge.
All right. And that cause number, the court is going to sentence you to 5 years. Give you credit for any time served. This will run concurrent with 2025 CR 008991. And the court will request the therapeutic community. State, you may be excused. Thank you. Did you review the document certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I did.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak with an attorney. Do you understand?
I do.
All right, good luck to you.
Thank you.
You're welcome. Oh, and counsel, let me give this to you.